Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. Just yesterday, the sixth semester started and I have given a brief introduction regarding the professional ethics. A case law has come from Allhabad High Court regarding the professional misconduct or section 35 of the Advocates Act 1961. Honorable Justice Bhanot, Ajay Bhanot of Allhabad High Court, while inquiring into the miscellaneous bail petitions, bail application number 14553 of 2022. Yesterday, in the case of Noor Alam versus State of Uttar Pradesh, held that the impediment caused by the advocates for the examination of witness due to their strike amounts to professional misconduct and also contempt of the court. Very lengthy sentence, but I will cut into pieces and make you enlightened in this particular topic. Please remember, in Andhra Pradesh also, Mr. Tandava Yogesh, a practicing advocate of AP Amaravati High Court, AP High Court at Amaravati, he has also filed a writ petition regarding the strikes by advocates, which is hampering the process of the trial, and he relied on the very famous case of ex-captain Harish K. Uppal versus Union of India. We all speak fair trial, speedy justice, just like very famous case Hussain Ara Khatun versus State of Bihar. Article 21 says, yes, speedy trial, speedy justice is also fundamental right under Article 21. Okay, but if the impediments like strike by lawyers are being caused, then what to be done? It can be taken as a professional misconduct and also contempt. You know, while dealing with the Constitution also, you might have heard the contempt proceedings by the High Court as well as the Supreme Court also. Right. So, the bench of Justice Ajay Bhanot, lawyers who strike work and who impede the process of the court by failing to examine or preventing the examination of the witnesses, particularly who are present in the court, definitely they are liable for professional misconduct, and the Bar Council is the duly empowered to take action against them under Section 35 of the Advocates Act. The genesis of the problem goes like this. This Noor Alam and others, they are the accused in a particular case, in a non-bailable case. They were arrested, they filed 3 bail petitions, but the petitions were rejected, and the Honorable High Court has given directions to the trial court to expedite the trial. Right? Then they will consider the bail matter. So no bail, but you expedite the trial so that after the trial is completed, they can look into whether to give bail or not. But still, even though the people are imprisoned from 2017, the trial has not concluded. Reasons: lawyers are going on strike. On one cause or other, in Allhabad district courts, they are going on strike. So, the lawyers' strike is directly responsible for the delay, and it is violating their right to prompt trial. And the court did not agree with that, they did not satisfied. They have asked for the status report from the trial court. The status report from the trial court also reveals that the delay is due to lawyers repeatedly striking work, which hindered the examination of witnesses. And this caused obstruction to the court process and also resulted in a failure to comply with the High Court orders also. So definitely it is a very, very serious issue. And now the court says, strikes by lawyers have emerged as a major menace to the judicial system of the courts, and they are threatening the rule of law. Common man bears the brunt as usual, but witnesses are harassed as they have to repeatedly attend the court, is it not? Suppose if I attend the court today, if my examination is done, finished. But asking him to come on so many days because of the lawyer strike is not good. So therefore, definitely bail is given and the matter is being reported to the so-called Uttar Pradesh Bar Council to take action against the erring advocates who are participating in the strike. This is one side of the coin. By now, you might have understood the lengthy sentence's meaning. Number one, the lawyers should not go for strike. Number two, even though they go for strike, there should not be impediment in the examination of witnesses. And for that is so-called for trivial reasons, they should not call for boycott and other things. But how they are able to do it? This is also the other side of the coin you have to understand. Because, for example, Ongole, the association of lawyers is called as Bar Association. This Bar Association is duly registered under the Cooperative Societies Act, or it is duly registered because Article 19 says you can form an association. When you form an association, what is the purpose of the association or union? Collective bargaining, is it not? So, as lawyers who know the law or who are the social engineers, if you don't raise up any issue, if you don't protest, if you don't boycott, if you don't go on strike, who else is going to do that? Particularly in legal matters. Therefore, lawyers will engage in strike. So already these are all the two sheets of the same this thing. సో షీట్ అంటే మీకు తెలుగు అర్థమవుతుందో లేదో. సో ఒక వరలో రెండు కత్తులు ఉంటాయి ఇప్పుడు. ఈ రెండు కత్తులు ఒకదానొకటి కొట్టుకోవు కానీ కొట్టుకుంటే డేంజర్. సో కాబట్టి ఎనీవే వాట్ యూ హ్యావ్ టు లెర్న్ ఇస్ యాజ్ ప్రొఫెషనల్స్ lawyer should not participate in the strike. That's the thumb line, right? So if you read the judgment, you will understand the intricacies. Okay. With this, I am concluding. Thank you very much.